So hello everyone, greetings from ICSID and SIMC. I'm Chuan Wee Meng, CEO of SIMC. On behalf of ICSID and SIMC, I would like to express our heartfelt appreciation for each one of you for joining us this evening. This is Friday evening for us here in Singapore, and I believe for some of you from the rest of the world, it's different times. And for those of you in Singapore, thank you. You may even have a glass of wine with you right now, and I ask that you sit back and enjoy this session that we have for you. We've initially reached out to a small group of senior practitioners, and we're so honored that more than 60 of you have signed up, all legal luminaries from various countries. And we appreciate that you have graced us with your presence here today. I know we have participants from 15 countries, including China, Japan, Korea, India, UK, the EU, Peru, Kenya, Canada, and of course, USA and Singapore. So thank you for joining us. This is a happy occasion. We celebrate the beginning of a deeper friendship between ICSID and SIMC with the signing of this MOU. This MOU provides for the use of SIMC facilities and services for mediation proceedings conducted under the auspices of ICSID, with enhanced technical collaboration between the two centers. This will complement the use of mediation to settle investor-state disputes, in particular those involving Asian investors and Asian states. By some estimates, the Asia region will account for over half of the world's GDP by 2040 and 40% of global total consumption. SIMC is honored indeed to be the first cooperation agreement for SIMC is honored to be the first cooperation agreement for ICSID to be signed with a center that's exclusively focused on mediation. After the signing of the MOU, we will have a discussion with our esteemed panel, followed by Q&A. Before I hand the floor over to Mr. Gonzalo Flores, Deputy Secretary General of ICSID, let me convey apologies from Ms. McKinney, Secretary General of ICSID. Unfortunately, she's not feeling well today. Mr. Flores has been with ICSID for many years, first from 1998 to 2001, and then from 2002 to date. Prior to joining ICSID, he was in private practice in Chile and holds degrees from Cornell University, the Chile Law School. I hope I pronounced that correctly. Mr. Flores.
Thank you, Wimeng. Thank you very much for those words. And yes, you pronounced everything perfectly well. Good morning and good evening to everyone. Thank you for being with us today. I am delighted to be here. As Wimeng mentioned, Secretary General McKinney was looking forward to being here with us today, but unfortunately the last moment matter prevented her from attending this ceremony. But she asked me to please convey to all of you her best regards and wishes of success. Thanks for joining this ceremony, which marks a new cooperation agreement between ICSID and the Singapore International Mediation Center. As was mentioned before, this is the first cooperation agreement for ICSID with a center that is exclusively focused on mediation. And this reflects the fact that mediation is today a key focus of our work. It also speaks to the importance of partnerships in developing mediation as an effective dispute resolution mechanism for international investment disputes. ICSID and SIMC have put a lot of effort in raising awareness of the attributes of mediation as an ISDS tool in recent years. Both institutions have also focused on building capacity amongst mediators, government officers, and ISDS specialists on the practical skills needed to mediate international investment disputes. As you probably know, ICSID is currently developing new procedural rules for mediation, which are specifically designed for investor-state disputes. So it is only fitting that the event today is not just a signing ceremony, but also a conversation on the opportunities and challenges with respect to investor-state mediation. Again, on behalf of ICSID, I thank you for joining us, and I turn the floor over to my colleague, Mr. George Lim, to say a few words on behalf of SIMC. Thank you very much.
So thank you, Mr. Flores, for those remarks. just a little bit about George. George is the chairman of SIMC, and he's been identified by the International Who's Who of Commercial Mediation as among one of the world's leading commercial mediator and thought leader, especially in the area of mediation. So with that, George.
Hello, everyone. Let me first say how honored and delighted we are at SIMC to enter into this MOU with ICSID. On this special occasion, please allow me to share some brief thoughts on the resolution of investor-state disputes. I think you all know that UNCITRAL has initiated a working group 3, on investor-state dispute settlement reform. And we've been following the discussions with great attention. At a recent session, I remember a delegate from an African country shared that her country was facing a US $9 billion claim from an investor. And I think she said, with interest, it would come up to $10 or $11 billion. And she shared that if her country lost that case, it would have a devastating effect on its economy. So I got to thinking, seen from this perspective, managing investor-state disputes takes on a different dimension. It's not just about settling a case or having an arbitration over a case. If not managed timely and well, the outcomes may adversely impact international trade or even cripple economies, and particularly those of smaller and poorer nations. So just for us to bear that in mind, that was something which I learned, and I'm looking at investor-state disputes in a very different light now. I have personally mediated an investor-state dispute. This was several years ago. From my experience, let me share that early intervention is of utmost importance. This gives the parties a chance to preserve their relationship and continue the business investment. According to ICSID statistics, 35% of cases initiated at ICSID are either settled or discontinued. For me, this is very encouraging, okay? And hopefully with this collaboration, we will be able to promote the use of mediation and encourage states and investors to resolve their differences amicably. The world needs more peace and harmony. Thank you.
Thank you, George, for those remarks and stories and data. We'll now have the MOU signing online across 2 continents and a 12-hour time zone. I think that's quite something. So if I could ask you to sign the MOU in front of you right now. Right, thank you. Thank you for spotting both George and Mr. Flores. If you could hold up the MOU now for photo taking. That's wonderful. Thank you. Thank you. Thank you. Well, I will now hand the rest of the time to Anna Holloway, Legal Counsel at ICSID. Anna will introduce our distinguished panel and moderate the discussion. Anna, over to you.
Thank you so much, and congratulations to both ICSID and the SIMC for this memorandum of understanding. We have a distinguished panel joining us today to discuss the opportunities and challenges with respect to investor-state mediation, and I want to take a moment to introduce each of them before we move forward with our discussion. So first we have Wolf von Kumburg. Wolf is an experienced arbitrator and mediator and a Canadian and English qualified attorney who has over the past 30 years acted as counsel and sat as arbitrator and mediator in both domestic and international disputes across a broad variety of jurisdictions. As a former legal director and assistant general counsel to a major multinational tech company, where he was responsible for conflict management and the development of a dispute management process, Wolf has a deep insight into the investor experience in the context of seeking to resolve disputes. Wolf has also, in the more recent years, developed a substantial expertise in investor-state disputes, particularly in the context of mediation. In this capacity, Wolf has worked together with ICSID, the Centre for Effective Dispute Resolution, and the Energy Charter Treaty Secretariat to help develop protocols and policies and to facilitate training on the use of mediation in investor-state disputes. He has also worked with several states to put in place mediation protocols to be used in investment disputes. A certified CEDR mediator, AAA master mediator, and fellow of the Chartered Institute of Arbitrators, Wolf sits on the mediation panels of a number of institutions, including the CEDR, the Asian International Arbitration Centre, WIPO, and the AAA ICDR. Finally, Wolf has held a number of leadership positions within several ADR organizations and currently holds board positions with the CEDR and the AAA. In addition to Wolf, we also have Professor Lawrence Bu. Professor Bu is, as you all know, one of the preeminent arbitrators in Singapore and in the wider international arbitrator community. Based in Singapore and educated at the National University of Singapore, where he is today now an adjunct professor, Lawrence has headed the arbitrated chambers since its inception in 1996. Over the past 25 years, he has sat as arbitrator in more than 300 cases administered by institutions including SIAC, the ICC, the LCIA, ICSID, the HKIAC, and the PCA, to name just a few. Lawrence is also a seasoned mediator and has mediated more than 100 disputes, with mediations reaching settlement at a success rate of 75%. Lawrence is also on the panel of many institutions, both as mediator and arbitrator. In addition to ICSID's panel of arbitrators and the SIMC's panel of mediators, Lawrence has been named to the panels of the AAA, the AIAC, and CTAC, among others. In the course of his career, Lawrence has also played a significant role in the development of law in the arbitration and ADR spheres in Singapore and internationally. In this respect, he's acted as a state representative to the UNCITRAL Working Group on Arbitration, as a consultant to the Attorney General's chambers addressing matters of law reform, and has sat as a member of various governmental committees addressing ADR law reform. And our last panelist for today is my colleague, Fraka Nitschke. Fraka is actually tied up a little bit in a case-related meeting right now that she can't leave, but she hopes to be able to join us during the course of our discussion. And so in anticipation of that, I will give a brief background for her as well. Fraka is a team leader and senior legal counsel at ICSID, and she holds law degrees from the Freie Universität Berlin, the Georgetown University Law Center, and Fern Universität in Hagen. And she is an accredited mediator. Fraka joined ICSID in 2003 and has had in her role there a fascinating window into the development and evolution of investor-state settlement over the past 2 decades. In recent years, Fraka has been a principal driver for developments at ICSID regarding the mediation of investor-state disputes. This has included the development of ICSID's first set of mediation rules, which were prepared as part of ICSID's broader effort to update and further modernize its procedural rules for resolving investment disputes. In addition, Fraka has been at the forefront of ICSID's capacity building efforts to enhance knowledge and awareness of investment mediation. And these efforts have included the co-organization of a series of events on investment mediation, and the organization in conjunction with the CEDR, the International Mediation Institute, and the Energy Charter Treaty Secretariat of a 3-day course held every year for experienced mediators and government officials. And she is an instructor in that course along with Wolf. Fraka has also published articles and speaks regularly on the topic of investment mediation. So before we move on to our panel discussion, I wanted to remind our audience that the schedule allows for about 30 minutes for the panel discussion, and I think I've already taken up about 5 of those for introductions. And we also have another 15 minutes available for a Q&A session at the end. I encourage you all to send any questions you may have via the Q&A function that you should see at the bottom of your screen on your Zoom platform. I'll do my best to moderate these questions and pose them to the panelists when we get to the Q&A section of our schedule today. We had hoped that Frauke would be the first speaker today, but in her absence, she has asked me to address briefly the topic that she was planning to discuss, which was the background of investor mediation in the context of the ICSID mediation rules. I will address this topic to the best of my ability through the lens of the ICSID rules amendment process, which began back in the fall of 2016, because this mediation background was really the impetus for the production of our draft mediation rules in the first place. So as we entered the rules amendment process, it had become increasingly apparent that mediation rules might be something that ICSID should add to its offerings. And there were a number of factors that gave rise to this view that this would be welcomed by our member states. First, over recent years, ICSID's member states have increasingly acknowledged the suitability of mediation for the resolution of investment disputes. And this is evidenced firstly in the evolution of bilateral and multilateral investment treaties. In recent years, we've seen a new generation of treaties that have been negotiated that refer expressly to mediation, either as a prerequisite to arbitration or as a standalone mechanism for dispute resolution. This marks a move from a prior generation of treaties that may have made bare references to amicable settlement or perhaps to the sort of generic non-binding third-party procedures. And treaties which have included explicit references to mediation include most notably the CAFTA-DR Free Trade Agreement from 2006 for Central America and the Dominican Republic, the COMESA Treaty for the Common Market for Eastern and Southern Africa from 2007. And then in more recent years, we have seen CETA, the EU-Canada FTA from 2017. Which goes so far as to contain a full annex prescribing a mediation process and stipulates that parties can resort to mediation at any point in their dispute. And similar provisions to this are contained more recently in the EU-Singapore Investment Protection Agreement and the quite similar EU-Vietnam Investment Protection Agreement, which were signed in 2018 and 2019 respectively. And the same period of few years, 2018 through 2020, has also seen a number of interstate BITs and model BITs contain express references to mediation. In addition to this, we've also seen a big push by states and other actors within the broader international community for mediation to become a bigger part of the menu of dispute resolution options for investment disputes. So for example, we have seen in 2016 the publication of the Guide on Investment Mediation, which was adopted by the Energy Charter Conference, which included 57 of ICSID's 155 member states. And as members of this audience will be familiar with, I imagine, there has been significant multilateral work on the Singapore Convention for the Enforcement of Mediated Settlements. A third aspect is that this was simply what we were hearing on the ground. In the course of the build-up to our rules amendment process and during its early stages, we had many interactions with state officials who quite clearly expressed a desire for mediation to become more accessible. Against that background of what was happening in terms of the world outside of ICSID and the world of ICSID's member states in particular, as was already mentioned today, the data from ICSID's arbitration cases really showed the potential for mediation. As George mentioned, we have concluded, of all the cases concluded at ICSID, nearly 33% have been either settled or discontinued. And at least 22% those cases in which there was a discontinuance at the request of both parties, or in which the parties had requested an award embodying the terms of their settlement agreement, we know for certain that those cases were actually settled, and also that settlement might have been facilitated by mediation. So to bring these developments together, it really appeared to us back then that the time was ripe for a bespoke set of ISDS mediation rules. And that leads me somewhat to our proposed mediation rules. The rules are, as I think Gonzalo mentioned, the first set of institutional rules that are designed specifically for investor-state disputes. Our rules are intended to provide states and investors with a neutral, trusted forum to engage in facilitated negotiation, to provide a party-driven, flexible process to allow tailor-made solutions. The parties remain in full control of the process and outcome of the mediation. The rules do not stipulate a specific mediation style, but leave that to the agreement of the parties. The rules also offer a time and cost-effective dispute resolution process. And lastly, I wanted to emphasize that when in drafting the rules, we ensured that the rules would facilitate any settlement agreement arising out of a mediation conducted pursuant to them to be compliant with the requirements of the Singapore Convention. And against that background, you may also be asking, well, what does a mediation look like under the ICSID mediation rules? That's a topic for a longer discussion, but at the highest level, the rules provide first a process for initiating a request for mediation. And importantly, under the proposed rules, mediation can be requested not only where there is a pre-existing agreement between the parties to the dispute to mediate, but also where one party wishes to use the ICSID mediation framework in order to seek agreement to mediate from the other party, which is an innovation we think will be welcomed by state and investment parties to disputes. The rules then provide for a process whereby a request is screened and registered or not registered if it's not capable of being registered. And then the process will move on to the appointment of 1 to 2 arbitrators. And the rules provide a mechanism for ICSID to assist with the appointment if necessary. Thereafter, the parties will submit written statements prior to a first session, and the end product of that first session will be a mediation protocol, which is the procedural document that will provide the framework for the remainder of the proceeding. The heart of the process, of course, will actually be the conduct of the mediation itself that follows, and in particular, the various sessions with the mediator or mediators and the parties, which typically have as their goal reaching a settlement to resolve all or part of the parties' dispute. And finally, the rules provide mechanisms for terminating the proceeding via a number of routes. So that is all I'd hoped to convey today on behalf of Frauke. And so I'd now like to hand the floor over to Wolf, who will be talking about investors' perspectives with regard to mediation of investment disputes, and also the policy considerations and other matters that states may wish to keep in mind in the area of investment mediation. Wolf?
Thank you very much, Anna, and I'm very pleased to be here with you today. I think this is an extremely important event, and when I saw that ICSID and SIMC were getting together in promoting mediation in this very important sphere of investor-state disputes, I was really happy to be invited to the panel. I must say, first off, that ICSID has played a real leadership role in the introduction of mediation to ISDS. Given its status as the primary institution with respect to dispute resolution in trade issues, it's really very meaningful that it has taken this role, and as Anna has pointed out, to the degree of actually now being ready to promulgate mediation rules. And I think that's going to be a very important aspect in kickstarting the use of mediation. And it's very fitting that this is taking place here in Singapore, given that Singapore has been a thought leader for many, many years. And I put George Lim certainly in that category of thought leader with respect to the development of mediation generally, and culminating, of course, in the Singapore Mediation Convention, which again is an extremely important document with respect to the utilization of mediation globally, and giving real legitimacy and credibility to mediation. And I applaud very much what Singapore has done in that regard. And so I think the two coming together here is extremely meaningful. As Anna said, I spent many years as in-house counsel for several technology companies, and I saw firsthand the way that investment disputes could be destructive, not only for the companies involved, the investors, but as George very poignantly pointed out, for states themselves. And we have to remember that investors come at an investment, of course, from a commercial perspective. That's only natural. That's what companies are there for. And they are looking for an investment that will bring a return to their shareholders. But states, of course, have a very different perspective. And we often forget that states are not only coming at this from a commercial perspective, but they also have social and policy considerations against a political background. And that, of course, is part of the issue here when we talk about the utilization of mediation. It's looking at some of the obstacles in particular that states face in negotiating any kind of settlement, let alone a mediated settlement. And so I'd like to talk a little bit about that in the context of the utilization of mediation. As we know, mediation from a commercial perspective has a lot of advantages. It's cost effective, it's relatively speedy, and it's efficient. As we just heard, Lawrence resolves approximately 75% of his mediated cases through mediation. And that's a fairly consistent statistic when mediation is applied to commercial disputes. But there are other real advantages that states have in the early use of mediation, and George alluded to this already, that's key, the early use of mediation. And as we are coming out of this global pandemic that has created economic havoc across the world, states will be particularly interested in foreign direct investment. And that will be a global phenomena. And one of the key elements as an investor that you're looking for is legal stability with respect to any disputes that might arise between yourself and the host state. Providing a backdrop where mediation is one of the tools that can be utilized for any investment issue that arises is extremely important. And having worked now for several years with both the ICSID and the ECT and their member states in looking at additional means, so additional to arbitration, which is the traditional means of resolving these disputes, states are actually very eager, and it's amazing how the response that we've received to looking at mediation as an additional mechanism that can be employed in order to resolve these disputes early, because obviously in many cases there's a relationship there. There's a relationship that if the dispute is caught at an early stage, might be maintained for the benefit of both the investor and of the state. So utilizing mediation as a tool is something that's being recognized as being extremely beneficial, and utilizing it early on. And so I think the pandemic in a odd way will actually be a catalyst for both investors and states to start looking at mediation as a true adjunct to arbitration. And Singapore, again, is an apt place to discuss this because mediation and arbitration for many years now in Singapore have been looked at as being tools that can be employed effectively together. So if we talk about med-arb-med or arb-med-arb, these are mechanisms that can very well also be employed in the investor-state arena, where mediation and arbitration can be put together in a process where both can be employed to reach a satisfactory conclusion at the end of the day that both the investor and the state can live with, rather than getting that $9 billion award against a state or potentially against the state. Finding an effective means of resolving that between the parties in an amicable way benefits both. Well, despite everything we said about mediation and the benefits of mediation, and clearly the interest in the use of mediation, there are obstacles that states face in any negotiated settlement. And this has been looked at by a number of different institutions now over the last few years. And the University of Singapore actually did a very interesting study on the obstacles faced by states in negotiated settlements. And the key obstacle appears to be that state officials avoid the liability for taking decisions. So it's easier simply to have a third party, an arbitral tribunal, render an award that is then enforceable, rather than the state official having to make a determination on whether to settle something and thereby perhaps put themselves in a position where they can be criticized, or perhaps even worse than that. The other issue is that states often, when a claim arises, don't have a clear administrative framework for dealing with those disputes. So it's difficult in many cases for a state official to have adequate authority from the state to actually settle a matter because it's not clear and there isn't a defined process for them to do that. And the key here is a process that's put in place before the dispute actually arises, rather than trying to scramble to find a mechanism while the dispute is ongoing. The other area, which is also one that arbitration has faced in the investor-state arena, is transparency versus confidentiality, and the need, of course, for a state to be much more transparent in what it is doing with respect to a dispute than to commercial parties, where confidentiality is usually a given, particularly in mediation, where that's one of the hallmarks of mediation. So mechanisms have to be found to allow a certain amount of transparency, even in a mediation type process where states are involved. And another very important factor, which is often overlooked, is that of state budgets, because it's often not clear within a state if there is a settlement as to who is then responsible for the payment of that negotiated settlement, as opposed to an award against a state, where there is typically then a clear mechanism for the state to have to pay the award. So within the state administration, there is often then a reluctance perhaps to settle because of the budgetary circumstances or issues that arise. So those are, some of the statistical obstacles that have been raised with states perhaps being more reluctant to mediate. Some other perhaps administrative obstacles that we've recognized and are trying to address are the lack of awareness of mediation as an alternative by states. So just the lack of awareness within state administrations as to what mediation is and how mediation can actually be employed in these disputes. And then the fact that there's an insufficient legal framework to support mediation and mediated settlements in many cases. And without that, it becomes very difficult for state officials to engage in mediation. Well, over the last few years, ICSID and ECT and CEDAR in particular have been working together to try to overcome some of these obstacles. And Anna has already mentioned some of these. There's an ECT, a mediation guide that the ECT published for its member states, which in great detail actually sets out the mediation process and how mediation can actually be employed in investor-state disputes. So it's a document well worth taking a look at on the ECT website. The other very important document that was promulgated by the ECT about 2 years ago is the ECT model instrument. And what that attempts to do is provide a framework for states to actually employ internally, which puts in place the process. As I discussed, the lack of process within a state when a conflict arises is one of the inhibitors to the use of mediation. By creating this model instrument and by implementing it, it creates a framework for the state to deal with any dispute that arises actually that the state is involved in, but also provides for the use of mediation and how a state official is then authorized within the mediation process to negotiate and potentially to settle a matter. So it's a very flexible document. It can be really employed by any form of state administration. And so again, another document well worth taking a look at. The International Mediation Institute, which George and I are very familiar with, it actually came up with an investor-state mediator. So for mediators, competency criteria. So it actually looked at what are the different competencies that a mediator needs in order to be able to partake in an investor-state mediation. And so again, that's another important factor, so that mediators are actually then trained to a standard which allows them to mediate this kind of dispute. And as we've already heard from Anna, we are expecting the ICSID mediation rules to be promulgated shortly as well. They actually follow the IBA investor-state mediation rules, which are now about 11 years old, and that were really the first hallmark of people starting to look at the use of mediation in these types of disputes. So with that, I guess just a couple of more things. ICSID has been at the forefront, as Anna said, of training mediators and now state officials. So it and the ECT are very much involved now in getting the message out to states and state officials as to what and how mediation can be utilized in this context. And just finally, I'd like to say, I think the Singapore Mediation Convention itself will be a catalyst as well. There's some debate as to how that applies to investor-state mediated settlements, and states might take some exception to the application of the convention to themselves, but that's yet to be seen how that will pan out. But the very fact that mediation has been recognized by the signatory states as a legitimate and credible mechanism for the resolution of disputes gives it a lot of weight in this context as well. So Anna, with that, I'd like to turn it back over to you.
Thank you all very much. We're going to hear last from Lawrence, who is going to share some observations about the potential for mediation of investment disputes. And he's going to speak to that particularly from the perspective of an investment dispute arbitrator, but also mediator. Thank you, Lawrence.
Thank you, Anna. Thank you for having me. When I was invited, I did confess to everyone that I have not mediated any investor-state disputes, although I have been involved in investor-state arbitrations, both in ICSID and non-ICSID cases. But I must tell you, I'm sold on mediation for any kind of disputes. And therefore, I'm convinced that even investor-state disputes are solvable through mediation. I have no doubt about that. Because I have seen far too often that whole states that have been found liable for breaches under any bilateral investment treaty tend to suffer more than they should in terms of costs, the negative image that comes with sometimes a drop in credit rating that would have come following the making of the award. In fact, when you look at the cases that are reported that have been cited against states, some of these breaches are not egregious. Some of them are negligence. Some of them may be a wrong decision made by the politicians. Some of them may be wrong policies that has been promulgated by a new government or the previous government. The sad thing is that the whole state has to bear the whole burden of the errors of a few individuals, which then cause a lot of hardship on the people of the developing states, sometimes impoverishing them. Like George mentioned, one example of one concern by this state that is now facing a $9 billion case. It will have a very impact on the economy, on the livelihood of people. So I can see that there are many good reasons why states should always stand ready to meet and address the complaints early. There are solutions to any given dispute. I'm convinced that any given dispute, there will be a solution to it. So if I may suggest, even when arbitration proceedings have been commenced, states and investors must stand ready to avail themselves of this avenue. The ICSID rules provide actually for a conciliation process, but as far as I'm aware, I think the take-up rate has not been very good, not very enthusiastic. And therefore, I'm very pleased that we now have a separate set of mediation rules, at least in the works in draft form, that once it comes into play, hopefully a greater sell to states and investors to buy into this mediation process. I agree with what Wolf has shared earlier. The council and state party representatives may often have some difficulty suggesting or agreeing to mediate with the other party. It may be seen as by its political bosses as a sign of weakness or accepting some degree of fault. And as well as, civil servants do not often dare to make decisions. They can't make decisions on behalf of the state. There are many hierarchy, many rank above them, above the people who appear at arbitrations or are actually conducting the arbitration or giving instructions to the council. They don't see solutions. They see a problem that they have to get rid of. And that is why a mediation session, a mediation process helps parties to find the solution rather than to see how to get rid of a problem. So in order to achieve this, we need to see enlightened and confident leaders who could then help another state to decide to make such a decision. I want to transpose some practices I have made in commercial arbitration, and perhaps that can be helpful. Just one or two points that I'm thinking of. In commercial arbitration, I would regularly provide a window in a procedural timetable for parties to engage each other to consider the use of arbitration, mediation. So there will be steps in the procedural timetable, and we'll carve out one window, a month or two, for parties to consider mediation. I believe that this prompts the parties in the right direction. And by providing that in a procedural timetable, no one will have to go back to report to their bosses to say, oh, we have agreed to it. It was the tribunal who has provided such a window. I must say that so far, in my experience, I have no issue with parties objecting to such a provision in the timetable. In fact, they welcomed it with smiles, because they have not thought of it. Except that I do sometimes have questions from my co-arbitrators and asking why is there wisdom in doing so. As I said, I believe that this prompts a party in the right direction, that there is a signpost for parties to pause and ponder so that no one is seen as weak. Because I see myself as an arbitrator who have a duty to assist the people to solve their disputes. And solving their disputes is not necessarily adjudicating on the rights and wrongs. A dispute can be resolved through other means, even if the matter has now appeared in an arbitration. To remind all, mediation can be commenced at any time and at any stage, even during the arbitration. I think we have quite a few years now introduced in Singapore this system called ARB, arbitration, and stay of the arbitration proceeding midway through or some stage of the arbitration process, and allow the parties to go to mediation and thereafter come back to arbitration. If there is a settlement achieved, then it will be made in a consent award. If there's no if there's a settlement achieved, it will be a consent award. If there's no mediated settlement achieved, then the arbitration will revive and continue the process. Of course, when this was conceived, it was to overcome the fact that Med-Arb process may not achieve the objective, the possibility of enforcement under New York Convention. To overcome that, we come with Med-Arb. But I can see that being used in investor disputes, because there is actually a window for investor state arbitration to provide for such a process. It all depends on the tribunal. The tribunal must be enlightened and be bold enough to want to do it. The other comment I want to make is in terms of investor state disputes, arbitration, is that they all arise from, of course, my definition of investor state means that they are treaty claims. Of course, treaty claims must arise from treaties. And I must say that it's very refreshing to see new treaties now have mediation provisions. As what was shared earlier, some of them even have schedules, detailed ways of conducting mediation or obliging parties to go to mediation. In fact, historically, many BITs, bilateral investment treaties, do provide for compulsory cooling off period, or what they call consultation period, before the commencement of arbitration. Because this is a compulsory period, sometimes parties just go through it as a matter of course and do not take that seriously. And the next day, they waited for the time to cool off, to pass, and then they commence arbitration. But I think mediation is a more active step. Mediation is not a challenge to arbitration. Mediation is an added initiative, an added possible way of helping the parties, a much more efficacious and a much more effective way of helping the parties achieve it. And I'm very pleased to note very recently, in fact, I just discovered it yesterday, that in the latest BIT signed between Singapore and Indonesia, which came into force just 2 weeks ago, it has, apart from the consultation process, the consultation provision, a mediation provision in Article 16. I find it's very refreshing to read that provision, because that provision does not mandate mediation, but it says that at any time, any party can request for mediation. And the other party must give sympathetic consideration to that request. So these are encouraging words. It does not say that you must within 30 days file a mediation. It's at any time in the court process of the dispute. And the party receiving it is obliged to give sympathetic consideration to the request. Clarifying also that the mediation process is voluntary and without prejudice. And what I like about it is also that it gives the parties the liberty to adopt any rules of mediation, of any mediation institution, or such other rules that they may wish to agree to. Such a provision is not very complicated. It's just a one-page provision, which I thought was very enlightened, because it encourages, it pushes, it nudges the party to go, the state parties as well, to go to mediation. The Article 16 of this particular BIT does not prescribe the process. It does not say that you must file the mediation notice within a certain period, thereafter you can't. No, at any time. It gives maximum freedom for a party and for party to agree, and in fact gives party autonomy, just like in arbitration. That's why I say it's so refreshing and enlightening. And an added feature in this particular BIT is that it does not say that if you fail in the mediation, then you continue arbitration. No, it doesn't. It simply says that if whatever the result of mediation, if it is successful, then it can be made into an award if they wish to. But in any case, the mediator can make a report. And this report as to the process that has been undertaken may, by agreement of parties, be presented if they wish to the arbitration, if there should be a subsequent. The whole idea, of course, is to encourage them to see the issues, to agree on issues if it's possible, if not, or reach a final settlement if not. If otherwise, if some issues have been agreed, this will be helpful in the later process. The reason why I share this is because I'm excited to see that BITs have changed its flavor. It's no longer just pushing parties to arbitration and pushing parties to take enforcement action. Here, there's a slow nudge, a very gentle nudge. And I think that's what BITs can do, states can do. That's what we as arbitrators, those of us who sit in arbitration can do, nudge the parties. I've heard, you have heard Wolf saying how difficult it is for state parties to agree to go to mediation. Indeed, it is difficult. The process is slow. Nobody wants to make the decision. We, as arbitrators, can help in that process. I'm very pleased to be involved in today's ceremony. It's not just a signing. I think this marks a very good beginning, a very good start in progressing and pushing gently, albeit, the parties, state parties in particular, to adopt mediation process in resolving their disputes with investors. I hope this helps to encourage them. Thank you.
Thank you so much, Lawrence. It's great to hear your enthusiasm for the possibilities of mediation for investment disputes. It looks as though, well, I should firstly convey sincere regrets from Frau Konitschka, who has confirmed she will not be able to make the remainder of today's session. And she asked me to convey how sorry she is that she wasn't able to join this conversation about a topic that she holds so dear to her heart. But I'm sure there'll be plenty of other opportunities for her and Lawrence and Wolf to collaborate and discuss on these matters in the future. We have some time left for questions and answers. Those attendees watching, you still have an opportunity to ask questions of our panelists. As I mentioned earlier, you can just type your question in the question and answer box at the bottom of your screen. And while we give you an opportunity to decide whether you might want to pose a question, I have a couple of questions for our panelists that perhaps they can start speaking to. And perhaps the first question might go to Wolf, although please, Lawrence, do chime in. You discussed, Wolf, a little bit about the obstacles that states face in terms of participating in mediation. And, I think you mentioned a number and those are real and significant. But of course, another key player in the resolution of disputes is parties' external legal counsel. And I was wondering how you see the role of traditional disputes lawyers who might be more familiar with litigation and arbitration evolving over time as mediation, particularly of investment disputes, becomes a bigger component.
Thank you, Anna. And yes, absolutely. Clearly, the legal counsel to both investors and states play a critical role in this because they are the advisors to those parties, and they themselves have to be familiar with what mediation is and the benefits that mediation can bring and how the process can be put in place. But they also have to be willing to go through that process. And of course, traditionally, because ISDS has developed so that largely arbitration is the means of resolving these disputes, it is also a matter of educating the lawyers. But it's quite amazing to see, excuse me, over the last 4 or 5 years as we've engaged in this discussion and have talked to the firms and the lawyers who are involved in ISDS, that they have also started moving towards an understanding that this isn't either mediation or arbitration. It's actually utilizing all of the mechanisms available, and they're recognizing that mediation is one of those mechanisms that can benefit both the investor and the state. So I think as we educate also the law firms, they will become a partner in actually utilizing mediation.
Oh, sorry, the terrible unmuting problem. I was going to ask Lawrence if you wanted to add anything to that, or should I move on to another question?
Yeah, I suppose traditional lawyers always and counsel always have an issue with a conflict within themselves as to whether or not to encourage mediation when there's a huge case there that is worth doing all the whole hog. There's always that tension. But I think enlightened lawyers do know that if they do a good job resolving a dispute with whether state parties or with their own helping, or whether they're representing state parties or investors, it always is satisfying, and hopefully there will be more, that will attract more cases, more briefs coming to them. And I think lawyers nowadays are probably very much more enlightened than before. There's an evolving mediation culture building up in many jurisdictions, I think in the US as well as in Singapore, in our region. In fact, in our region, there is a culture of trying not to litigate as often as what maybe Western states or Western parties tend to be. But of course, we also got into the habit of litigation and arbitration of once we open up the economy in Asia. But as I said, there is a mediation culture being slowly fanned and nurtured, and I think that will help. I think, as I said, lawyers are also more aware that their duty is to their client's interest and not their own interest. So the client's interest means is to help them resolve their dispute as soon as possible, the least cost as possible. That must be their client's interest, nothing else. So I think that is something lawyers, I'm sure, will do their best to do so.
Thank you. And I will now perhaps put a question to you first, Lawrence. You spoke a little bit about the actions you take, particularly in your commercial arbitrations, to create windows for parties to discuss the possibility of entering into a mediation. I was wondering if you could speak a little bit to how you feel that differs currently in investor state mediations. And in that regard, I know you had mentioned that in your mind, investor state mediation is, investor state arbitration is under a treaty. And we've talked, both of us, I think, about the evolution of treaties and how we're seeing more mediation in them. But assuming you are arbitrating an ISDS case where there is no such mention in the treaty, do you feel more constrained in some respects than in commercial arbitration? And what could be done to facilitate arbitrators to sort of think about these things more or feel more comfortable raising these issues, even if there isn't a reference to mediation in a treaty?
Thank you. Thank you. Firstly, I think you're absolutely right. I would be a little bit cautious at the moment if in investor state arbitration to suggest mediation in the process. But I'm emboldened, more and more emboldened, because of the trend in the kind of BITs that are being signed off, and the atmosphere is also different. As I said earlier, in commercial arbitration, even in commercial arbitration, sometimes I have arbitrators asking me, are you sure you want to do this? Why are we doing this? Apart from the fact that you are going to kill the arbitration early, is it within our mandate to do it? I think I'm now emboldened and quite prepared to do it if there is when there's an opportunity to do so, to suggest to parties, give yourself a window of opportunity to consider mediation. At least, in my view, a good time to do that will be after at least the statement of case and the statement of defense has been filed, and not too, at least the parties know each other's case, and that will be roughly a good time for parties to know what actually is at stake between them, and what are the issues that require determination, and how then they will be able to see the strength of their own case or the weaknesses of their own case. So I think that will be what I feel that I will probably try to do in future if there is an investor-state arbitration that comes forth, and at the beginning, and there's an opportunity to do so. Of course, one must also look at the state's structure, whether structurally they are ready. There might be difficulty in situation where if there's a change of government, and if the change of government is for an enlightened government, I think that will be even easier, because then it is not their problem. It was they are trying to solve a problem of the previous regime, so it might be easier. So there are a lot of factors that I have to consider before putting forward such a suggestion. But I would, as I said, I'm holding to do so.
Thank you very much. Wolf, did you want to add anything to that question?
No, I see that we're running out of time, but I think I go back to what I said earlier, and that is states have to start looking at mediation proactively and make it part of their process design, so that in particular, they create an attractive environment for investors. And so making mediation part of their dispute resolution process overall, I think, is a good way for states to use mediation proactively.
Thank you. And on that note, we have reached the end of our time, so we will end the questions there. I guess, fortunately, we didn't receive any from the audience, so I don't feel bad for failing to answer any. But I wanted to thank our panelists, Wolf and Lawrence, very much for their time today. And on behalf of ICSID and SIMC, to thank also our attendees for taking the time out of their days to join us for this illustrious Memorandum of Understanding signing, and also to join us for our panelists' discussion today. So thank you very much.